Hello, I'm Alexander Jeffrey, a law clerk with the Clark-Esposito law firm, PC, and today we will be discussing sanctions. In September 2021, a company based in San Antonio, Texas, agreed to pay over $180,000 to the Office of Foreign Assets Control for their potential civil liabilities and 52 apparent violations of the Iranian Transaction and Sanctions Regulations, the ITSR. For more information about the ITSR, please review our previous video. This company is known for making and producing 3D animation hardware and software systems. These apparent violations occurred when this company entered into an agreement with a third country distributor. OFAC believes that this company had reason to know or explicitly knew that their products would end up in Iran. In 2013, this company began to transfer their distribution in the Middle East from one company to another. This new distributor explicitly said in their contract that they would be distributing to Iran. Of these violations, the sales totaled nearly $500,000, but of this $500,000 in sales, there was only $60,000 in profit. All OFAC sanctions programs have a strict liability standard, meaning that whether the company in violation knew, had reason to know, or had no idea at all about their violations, they are still held liable. Here, this company clearly knew that their products would end up in Iran and would violate the ITSR, but believed that they would not be held liable because they were not the direct distributor. This strict liability standard is the reason why OFAC is very strict about declaring end users. Even though products may go through a variety of countries and channels, OFAC still requires that exporters forecast their end users. This company voluntarily disclosed their apparent violations to OFAC, and in turn, OFAC found that this was a non-egregious case. OFAC applies all violations to a tiered penalty system in which violators can either be given a warning letter or face criminal prosecution. In this case, OFAC looked at a variety of factors to determine the amount of penalties that they would issue. OFAC listed the aggravating factors of this case as the reckless disregard of sanctions requirements by authorizing distribution to Iran, possessing actual knowledge of the conduct leading to the apparent violations, and the facilitation of access to their products in Iran leading to a designated or blocked entity possessing their products. OFAC listed the mitigating factors as the proportion of the income for the apparent violation as compared to the company's total revenue, the remedial actions taken by the company since the apparent violations were facilitated, and the company cooperating with OFAC during the investigation. The most important lesson from any settlement agreement is understanding how the violator's compliance program may have been inadequate or had holes in it that allowed these violations to happen. In this case, there was a fundamental misunderstanding of liability when it comes to third-party distributors. Are you experiencing any issues with your overseas transactions or think you may have any issues moving forward? Please contact us at 917-546-6997 or reach out to us by email at contact@clark-espositolaw.com. We'd love to hear about your business. Thank you.
Subscribe and click the bell icon so you'll be the first to know when we upload a new video. Check out our playlist if you want to see more of our videos, and comment below and introduce yourself. We'll see you soon.